Hello from the IBFD. This is Pasquale Pistone.
And this is Philip Baker.
We are here to share with you the findings of the Yearbook 2024 of the Observatory on the Protection of Taxpayer Rights. 2024 was an important year, the year of the 10th anniversary of IBFD's Observatory on Protection of Taxpayers Rights. Philip and I are giving you first a general overview and then some facts about the new section of the IBFD Observatory on Protection of Taxpayers' Rights. As you will see, for this reason, this video clip is being split into two parts. Part one gives a general overview, and the part two will be on the artificial intelligence and automated services problems, which is a new section 13 added to the observatory. You can see on this slide our menu, our agenda, and I will guide you through those first 9 points. The protection of taxpayers' rights has made it possible to have data available across the years with empirical findings on the protection of taxpayers' rights shaped along the 12 points that Philip Baker and I have included in the 2015 general topic of the International Fiscal Association Congress. So we've been monitoring for quite some time the minimum standards and best practices on the protection of taxpayers' rights, and we've been covering for the past years 12 thematic areas. Now we have added one, so they are from now on 13. We're very happy to say that many countries have been monitored for several years. Some other countries have joined. Now we have 56 countries. And I think this is actually quite important because we provide the information. We provide information also on the changes from year to year. And then also we secure some traceability of our sources, all done in the English language. Now, what we have noticed in 2024 is that there is an increase in the digitalization process of tax administration. More the digital operational modes are visible, and there is an expanded use of artificial intelligence and automated services for compliance, audit, and communication. There have been some changes upwards and downwards in confidentiality, legal remedies, and cross-border standards. There is, in general terms, more transparency as to how tax authorities operate in the framework of procedures. But there are also some notable regressions in some jurisdictions, and you may find some more evidence in the general report. Now, we think that when it comes to the identification of taxpayers and the communication, there is some more rational structuring of the criteria used by tax authorities, and also we appreciate the fact that some countries are facilitating, are turning their system into a more user-friendly environment, such as the UK One Login system to streamline access across departments, but also the fact that some other countries like Brazil are using a sole ID for all public services is achieving some important results in terms of being user-friendly and also in streamlining the efficiency of how tax authorities operate, and in general, all public services provided by the states. Now, there is a clear need for securing digital communication and data access rights. And this is something which is visible already from the level of taxpayers' identification and communication. There have been important developments in 2024 that have influenced several areas of the protection of taxpayers' rights, and one of them is the case of Italy that mandates pre-assessment dialogue under the new Taxpayer Bill of Rights. This is a legislative development which influences also several phases of tax procedures. So I think it's actually important to say that it starts from the pre-filing practices and the tax assessment, but it goes across the whole protection of taxpayers' rights. And in several countries, we have seen that e-filing and pre-filled tax returns or pre-populated tax returns have become almost a standard for individual taxpayers. And also the fact that the use of technology is making it easier to reduce the time needed for refunding taxes paid in excess. And that is something which has brought us also to introduce a new minimum standards or several minimum standards for recording that across the different countries. Confidentiality has become more of a problem, and that is clearly in connection with the fact that more refiling and more activities are done digitally, and therefore it's actually quite important that there are rules, and we have seen that also in respect of data deletion and of remote work safeguards. When we talk about remote work safeguards, we talk about the work done by tax authorities not operating from the premises, from the offices of tax authorities, but from their home office. So that is clearly something which raises issues also for the fact that it might be more difficult to secure that level of protection. And also we have noticed that there are new standards, and we have set new standards also in the Protection of Taxpayers' Rights for monitoring the whistleblower protection. Brazil has increased the level of confidentiality with a national cloud strategy, and we have appreciated the fact that Peru has taken a more effective strategy when it comes to prevent possible breach of confidentiality by tax officials and actually adopting measures to counter that. However, negative trends have also been recorded in some countries, and one of these is Guatemala, and the fact that there have been public data disclosures is something which we consider particularly bad, and the same applies for Luxembourg, which hasn't been operating an effective control of how tax confidential information is handled. Now, when it comes to audit, we have noticed with pleasure that proportionality is becoming more important in the audit procedures, and that is visible in the developments concerning Italy and Greece. In Italy, it might be connected with the adoption of the new standards by the Law on Taxpayers' Rights, but also the fact that the nebis in idem principles have been secured in a stronger way. I mentioned that in plural also because, as you know, we have two aspects of nebis in idem, which is nebis vexari and nebis puniri, so the procedural aspect of the prohibition of double jeopardy, and also the one connected with sanctions. Once again, Spain shows that there is a trend, in particular at the judicial level, by the Supreme Court, to strengthen the protection of taxpayers' rights in the framework of audits. And in December 2024, we have seen some developments connected with the right to prior notification and with enhanced procedural transparency. There are some concerns once again in Guatemala and in the Chinese Taipei about the taxpayer procedures and the protection of taxpayers in the framework of those procedures. When it comes to reviews, appeals and hearings, we have noticed an expansion of online hearings in Greece and in other countries, and that is also giving you some more concrete dimension of how the developments are taking place across the world in the framework of digitalization. And that also includes the e-filing of appeals, which is possible in several countries. Now, US, Hungary and Botswana are some examples. But still, we keep noticing that the solvet repete, so the mandatory tax prepayment, is remaining a critical issue. So the fact that the taxpayer has to first pay taxes and then access court, that is something which has nevertheless been addressed in Nigeria with a positive shift in a judgment by the Nigerian court, which has declared unconstitutional the payment of a 50% of tax to access justice and of 100% of tax to have a judicial appeal, so to appeal a judicial decision. Cross-border issues and MAPs, mutual agreement procedures, remain an area which is particularly problematic. And we have stressed at least two big problems. One is that mutual agreement procedures still require to make progress towards transparency. They are handled in a way that it's not transparent and it's not publicly disclosed. And that is something which also relates to the right of persons to access, to have a more precise view of the conditions to access the mutual agreement procedure, the fact that there are discretionary powers without a transparency of how those powers are exercised, is somehow still a big problem in cross-border relations. But also, in the European Union region, the implementation of the DAC 7 in several countries is raising issues of protection of confidentiality, but also of the mandatory disclosure related thereto, which has been perceived as being problematic in some countries, including Lithuanian examples, which you might have a look at. Now, when it comes to the overall trend and the overall view of the first 12 points of the OPTR, we are saying that the best practice is making progress, so there is a gradual adoption, and this is also, what brought Philip and I to change the standard and also to indicate that what used to become a best practice might have turned into a minimum standard, but nevertheless, we still see that there are some isolated regressions. There are critical areas, and one of them is certainly artificial intelligence and its governance. And in part 2 of this presentation, we have thought about being more analytical. This is the first year that we are reporting on this 13th standard, so you will see that the presentation of part 2 by Philip Baker has some more specific relevance to what's happening in the various countries. It's the first year that we are monitoring that. But there are also issues with cross-border enforcement and taxpayers' remedies, which are yet to be addressed. What makes us very happy is that IBFD has brought together a number of persons interested in monitoring the development of the protection of taxpayers' rights and having a network of people corresponding from different countries and making all this information available for empirical research and international standard setting.
I'm now going to take us to a particular part of the report for 2024, and that is the new AI standards, chapter 13 of the report. When we did this work originally 10 years ago, it was really too early to discuss the use of artificial intelligence by tax authorities, but in the last 10 years, the possibility of using that has grown. And clearly, artificial intelligence offers great possibilities for tax authorities, but at the same time, there are significant dangers, and that requires safeguards. We've discussed this trying to develop minimum standards and best practices, unlike the work 10 years ago, where we worked from data to standards, because we didn't have the data here. We started from the literature, which discussed the potential dangers of the use of AI, developed some preliminary minimum practices, best practices and standards, and then we sent it out to the national reporters to see what the practice was in particular countries. And this 2024 report includes us for the first time. The minimum standards and best practices are under 3 headings: transparency, how far are people made aware that AI is being used; human oversight, to what extent can decisions be taken purely by computerized systems, or are there human interventions? And then some more broader questions of guidelines of fundamental rights. On these slides, we've set out the minimum standards and best practices. I realize that for many people, these are being seen for the first time. I'm not going to read through all of them, but pick up a couple of them. Clearly, if you want to go further, you can read the report, and all of the minimum standards and best practices are on the slide. So we start under transparency. Looking at the literature, we thought that a minimum standard was that all taxpayers who are subject to a tax compliance procedure that involves artificial intelligence or what we've also called automated analytical systems, they should be informed that such procedure will be applied. That was put out to the national reporters, and you will see that we have answers from some 60 reporters. Only 5 jurisdictions reported that at the moment that is the case, whilst 25 said it was not yet the case. And 30 countries, it would seem that artificial intelligence is not yet being used by the tax authorities, so that it was not applicable. Clearly, the vast majority of countries are not not meeting the minimum standard, but it's relatively early days, and the formulation of the minimum standard, in a sense, provides some guidance, and it'll be very interesting to see in years to come how far that number changes. A second minimum standard involves chatbots. To what extent, when you're dealing with a chatbot from a revenue authority, are you aware that you're dealing with a computer? Or might you think, particularly as machine-generated language becomes more like natural language, that you're dealing with a human being? Well, a slightly greater number of countries tell you that it's a machine, though most countries still don't tell you that. Where a decision has been taken in respect of a taxpayer by using AI, are the details of the procedure made available? Again, only in a small number of countries the answer is yes. In the vast majority, still, the answer is no. And then we identify a couple of best practices in this area. For example, where any decision relating to tax administration has been taken in respect of AI, is the taxpayer given full details of the criteria and algorithms? Is the artificial intelligence, is the taxpayer informed that it has been used? Again, only a minority of countries is the answer yes. In the vast majority, the answer is still no. So we're a long way from best practice in that area. If we go, for example, to the question of human oversight, a minimum standard is that no decisions that have made a significant impact on the taxpayer should be taken exclusively by AI, and a best practice is actually that no decisions should be taken exclusively by AI. The question that was asked was, are decisions that may have a significant impact done exclusively by AI? Yes, some countries that is the case, though here the majority of countries said no, significant decisions were not taken exclusively by AI. Another minimum standard concerns the availability of material generated by AI. You will see that in a minority of countries, that material is made available to taxpayers and their advisors. Majority of countries still either don't use AI or they don't tell that to the taxpayer. In terms of more general guidelines, do guidance notes, are they provided by the tax authorities for the use of AI? Some 28 countries said yes, guidance notes were made available. Then with regard to the algorithms that are used, if they are likely to have a discriminatory or distortive effect, then there's a minimum standard that they should not use those criteria. Very hard at the moment to assess that from countries, but you will see there the question, 13.4, a minimum standard. All tax administrations should appoint a senior official with overriding responsibility for the use of AI. And here, for those countries that are using AI, it's almost balanced. A much higher number of countries than some of the other earlier answers. 10 countries have a senior official reporting in this area. So we've attempted in our work in Chapter 13 to state some preliminary minimum standards and best practices, to get answers back from countries. This is going to be very much a developing area, and we will see as the years go by whether more countries approach the minimum standard and whether minimum standards perhaps become common across the world and best practices become minimum standards. With that, we've introduced to you the overall report and this new section, Chapter 13 on AI. We do encourage you very much to look at the full report, and we take the opportunity to thank all of the reporters who were involved in preparing it and all of the team at the IBFD. We are always looking for more reporters, and if having seen this video and read the report you'd like to become involved in this process, we always welcome that. So it's thank you and goodbye from me.
And goodbye from me.